One of the principles that we inherited from England was the idea that when people are charged with a crime or when they have a civil dispute, they should have that issue resolved by a jury of their peers, people like them from the community. That it shouldn't be resolved by a judge or an appointed executive. It ought to be resolved by a jury.
12 ordinary citizens participating in our government by coming to a verdict based on the facts and in accordance with the law. Jury service goes back hundreds, almost 1,000 years to medieval England, but justice in England did not begin with juries.
So what came before the jury? Trials by ordeal.
In ordeal trials, instead of a judge and a jury, a priest would usually preside. Innocence or guilt was not decided by facts, but by the belief that God would intervene on behalf of the innocent. There was no hearing on the evidence, no defense or prosecuting attorney, and the sentences were a bit out of proportion. In fact, most felonies were punished by execution.
Execution or worse.
And they called these trials by ordeal because, well, see for yourself.
One version was a trial by battle, where people could literally fight to the death over a disputed fact.
You could even hire them to fight for you. And most famously, there was the ordeal by water, where the accused was thrown into a river or lake. If he sunk, he was innocent.
After an appropriate period of time, the family would bring them up sputtering.
Of course, someone who floated was pronounced guilty, taken out of the water, and, well, you know. A few years before the ordeal trials came to an end, King Henry started to make some real innovations in the justice system through a series of acts handed down called the Assizes. Among the innovations of the Assizes was a new way to resolve disputes over property and inheritance. 12 free and lawful men from their neighborhood or village were assembled under oath to testify as to who was the true property owner or heir.
In medieval times, jurors were actually akin to witnesses. They were often drawn from people who had observed the incidents or knew something about the incidents in question.
These juries were self-informing. They were expected to come to the trial already knowing the facts and then determine guilt or innocence amongst themselves. The evolution of juries continued as Britain became more dependent upon written law in the 17th and 18th centuries. Lawyers became more skilled, and juries began to listen to each side present its evidence.
And judges were much more central to the conduct of a trial than they ever had been before.
But this led to certain abuses from the state. Juries could be severely punished for delivering a verdict that a judge didn't like. In 1670, when a jury refused to convict Quakers William Penn and William Meade of preaching in the streets, the judge fined the jurors and threatened to cut off the nose of jury foreman Edward Bushell. Bushell appealed, England's Chief Justice ordered him freed, and the right of the jury to act independently was affirmed. This independence was at the very heart of the rebellion in the American colonies, where the jury would continue to evolve.